Counsel?
Oh,
Yes.
Judge Gould.
What I was going to ask is this. You've alleged, or you've argued, that the program itself, the business model, appeared, from your client's point of view, to be extortion-like. Okay. So what I'd like you to do is just explain, putting your client's best foot forward, why the model is like extortion if you disregard the false statement that was in that affidavit.
Yes, I understand. Under the Highsight case that we cited in District Court of Arizona, and now the more recent Levitt versus Yelp case, we felt that the business model of Xcentric amounted to a scheme to induce economic fear and to profit by selling something that was a valueless sham. In the words of Levitt versus Yelp, really it was a protection racket. They participated actively in soliciting damaging statements and then proceeded to profit from those by offering to minimize or negate the harm that the subjects of the reports experienced in search engines. And so authority for that, as the district court found here in Arizona, was that that was a plausible legal theory as previously found in the Highsight case. And just a brief word, we do take issue with the idea that Section 230C1 fully immunizes them because Highsight was decided under Section 230, subsection F3. I'd like to reserve 30 seconds, if I could, for my co-counsel to be heard on a motion we have pending. Unless you have more questions, I'm happy to answer those.
Did you talk about the motion for sanctions?
Correct, Your Honor.
Why don't you say whatever you want to say about it?
This will keep happening. They didn't address the substance of our argument in the appellate briefing. And normally, I would take a hint from a district court judge and not move for sanctions. But the district court judge, in our case, said multiple times, just pointing out the reality, no matter what you do to amend the case, the fact still remains that your characterization of this claim is not what you say it was, because we can just look at the record. And he already told them it was vexatious.
You know, the sanctions motion strikes me as not particularly productive from your side. On the one hand, you're arguing that probable cause is a very low standard and your initial complaint sufficed to meet it and lawyers should be given a fair amount of room to run. I tend to agree with that, but if that's true, how in the world can we impose sanctions on your opponent?
It's more in the manner that it was litigated that was vexatious. They omitted material parts of the record. We then had to supplement the record to show the true nature of the complaint.
You're seeking sanctions for the trial court proceedings, correct?
No, it's only for the appeal. The appeal itself, we think the result is obvious.
Only for the appeal. So you think
Correct.
they shouldn't have filed an appeal at all?
Correct.
Okay, thank you very much.
Thank you, Your Honors.